Hello, I'm Ray Abadin, President of the Florida Bar. I'm going to be talking to you today about the legal profession, the legal marketplace, and the dramatic changes that are occurring to our profession because we are no longer a monopoly, we are no longer alone in the marketplace, and we have some very serious issues to discuss. The presentation that I'm going to give you is the product of 3 or 4 years of intense study by me, my predecessor presidents, by the entire staff of the Florida Bar, and many others, and is designed to inform you, to show you, and to discuss with you what's going on, how we should react, and what we need to do to provide high quality, efficient legal services to the public and the citizens of the United States. We've been studying the changes in the profession for the last 3 or 4 years. And if there's anything I can share with you that I know for sure, is that how you and I practice law in 5 years, just 5 years, will be very, very different than how we practice law now. How we practice law in 10 years will be very different than how we practice law in 5 years because of the dramatic changes that are occurring in technology, computing capacity, artificial intelligence, and really the business dynamics that apply to our professional services. More importantly, our interaction with clients, how clients interact with us, and how we as lawyers can and should leverage technology across really a borderless marketplace. What you're going to see over the next 20, 30 minutes is a presentation that we've been giving to the Florida Bar membership for the last year and a half that encompasses all of the changes, the new players in the marketplace, really a new market concept in the delivery of the practice of law. I'll start by going back to the beginning. The Supreme Court was created in 1845 and throughout the course of its history has created 2 separate arms really for management of the legal profession. The Florida Bar was created in 1949 and began in 1950 as a regulatory function in a place where lawyers could go to create an atmosphere to serve both the lawyers and the public. And I'll show you the Supreme Court case that started the Florida Bar. In 1955, the Supreme Court created a separate entity, the Florida Board of Bar Examiners. The Bar Examiners is the regulatory body that manages and oversees the education of lawyers and the transition of lawyers from law school to the bar exam and then over to the Florida Bar. This is the case that created the Florida Bar. It's the Supreme Court of Florida, Petition Florida Bar Association, June 7th of 1949, and I want to highlight some important language for you from that Supreme Court case. And really, if you think about it and you look at what the Supreme Court was telling lawyers in Florida in 1949 is they wanted a bar association to help restore the public's confidence in the profession, to energize the profession's responsibility to the public, and so the bar can share in its responsibility to the public and the profession. And the interesting thing about this from our point of view, in particular now in this new era, this 4th industrial revolution that we're in, is the emphasis way back in 1949 on the public. We as consumers now, the public now, we the public, the consumers, have a whole lot more power and access to information that even in 1949 we didn't have, no one had. But the Supreme Court says we as a bar, we as a profession need to emphasize the public. So we have been looking at the changes in the profession that have been occurring. And so in 2013, then President Gene Pettis created a commission called Vision 2016. 68 people, all legal professionals, got together and were told to look at 4 distinct areas of the profession: legal access, bar admissions, legal education, and technology. The real driver here is technology because, we all use iPhones, we all use iPads. The iPad is going to be 5 years old in October, or maybe 6 in October of 2016. Think about when the last time you sent a fax. Think about when the last time you sent a letter by snail mail. We are now completely, almost all digital native in how we create information. So the bar then, the leadership then, decided to study these 4 areas. The access to legal services became such a large area that Chief Justice Labarga and then President Greg Coleman last year decided to have an access commission, and they created the 34th Access to Justice Commission, which is studying the access issue. But the Access Commission has found is almost 80%. The ABA thinks it's 84% of the citizens of the state of Florida and the citizens of the United States do not have access to an attorney, do not have access to justice. And if you just think about the Pledge of Allegiance or the Constitution, the Pledge of Allegiance says liberty and justice for all. The Constitution talks about we the people. We've now identified 80% of the we the people that don't have access to justice, and the Access to Justice Commission is studying that. The other 3 categories are bar admissions, legal education, and legal technology. And you can see under bar admissions that we have been looking at multi-jurisdictional practice because of the borderless nature of the internet, because of the borderless nature of our practices, because of air travel and the conveniences we all have, and the consumer's right, the public's right, to access lawyers whenever, however they want. Legal education, all 12 deans in Florida have now agreed that we need to revamp legal education. We need to revamp how law schools teach lawyers. They have identified core competencies that they'd like to teach in law school. We are considering, and for consideration is the uniform bar exam in Florida, changing the bar exam, reducing the number of subjects on the bar exam, going to a national criteria for education of lawyers, to allow the law schools to then create time in the legal curriculum to teach core competencies, the how to do it. No longer is the profession able to train lawyers how to think like lawyers in law school and then train them how to be lawyers when they come out. And of course, technology has changed everything. Cybersecurity, which we'll talk about in a minute, the speed of which we move information, how we move information, and the new kid on the block, artificial intelligence, is really going to dramatically change how we deliver legal services. So where are we now in 2016? We're about to deliver all of the reports from 2016, and the recommendations are going to be coming out. So stay tuned to the Florida Bar News for further developments coming out of Vision 2016. The first thing we did is to recommend 3 hours of CLE specifically dedicated to technology. Not how to do a PowerPoint, not how to create a document, but how to understand the tools of technology. It's the tools that technology gives us that will make us better able to serve our clients, the public, that the Supreme Court talked about when we were formed in 1949. So the issues remaining are these, and they're a lot, and they affect dramatically every piece of our professional lives. And you can see them here, and the bar will be addressing these issues and will be making recommendations to the Supreme Court and to the Florida Board of Bar Examiners on the legal education side. It's important that you stay tuned to these issues because everything that the Board of Governors is doing will affect dramatically how you practice law in the next 3 to 5 years. So where are we now? The guy in the middle is your typical lawyer, autonomous, well-educated lawyer who, until very recently, was the only place you could get legal services. We were, for all intents and purposes, a monopoly. If you needed a lawyer, you had a legal question, you had to go to a lawyer and you get legal advice. What's happened now is we're not alone in the marketplace. This is but a sampling of companies, non-lawyer companies, some are lawyer-owned in a broad sense, that are providing legal services to that 80% that we have left unattended, to that 80% of the public that needs legal services. And these are technology-driven, internet-based platforms that are accessible to consumers, the public, that are providing some form of relief. I focus you on several. Ravel Law is a revolutionary legal research technology that will provide you with a dashboard of solutions for virtually every legal issue that you might have on your federal cases. You can plug in a natural language query into Ravel Law, and within 0.8 of a second, you will have a dashboard with that particular judge's rulings on that particular issue. Every time that issue has been addressed by that court or that judge, every order that's been issued on that, and it will tell you to a percentage certainty the number of times that that issue has been decided one way or another by that particular judge. ModeRIA, you'll see a video farther down in this presentation. Online dispute resolution. UpCounsel and Axiom are internet-based tech platforms that connect lawyers and consumers, as are many of these other ones. The ones we know about for sure, because everybody's been talking about, and you'll see farther down the presentation, LegalZoom and Rocket Lawyer and Avo are leveraging business practices, branding, marketing to come into the legal space through the internet. Since January of 2015, my predecessor and my executives at the Florida Bar and I have been crisscrossing the state of Florida. And this is just a little diagram of where we've been. You'll see we have 252 contacts, presentations, meetings with you, our constituents in Florida, the lawyers of Florida. We've done our best to cover the state, to talk about these changes, to give this presentation, to get feedback from you about what you think about these changes, to inform you about these changes. We've been able to go nationally. Florida is one of the thought leaders in the tech-driven changes in our profession. And both Greg Coleman and I have been privileged to speak to several bar organizations around the country on these issues. What we've heard from you is you'd like us to stop this competition. You'd like us to compete with this competition, or you'd like us to cooperate. And each of these three has their own inherent set of problems. You know, stopping involves litigation. Stopping involves using the tools of our trade to combat these companies. Very few people, if any, have been successful stopping. Competing creates economic issues. LegalZoom and Rocket Lawyer and Avo, to name just a few, are heavily funded with venture capital money. We in the legal profession have created rules that prevent us from accessing that type of capital because we can't share fees with non-lawyers. We can't work with non-lawyers. Corporate ownership of law firms is a very touchy issue for us, and so how we get money is very limited for us. Cooperation also has some issues because of the bar rules that we've imposed upon ourselves, some dating back to the turn of the century, that say, well, we really can't work with non-lawyers. Fee sharing is an issue. Partnership or ownership with non-lawyers is an issue for us. And so what we do and how we adapt to the marketplace is the subject of much discussion. To address the changes in technology affecting our practice, in January of 2016, we published in the Florida Bar Journal a magazine devoted almost entirely to legal technology. And so here's just a few of the articles that were published by thought leaders in our industry regarding subjects of technology and its effect on the profession, changes in how they're going to affect us. I urge you to read that at your leisure because it's one of the most important pieces we've published. What you see on the screen now is a law review article from Georgetown that is cautionary. It's a cautionary tale for us as lawyers. And the important thing here is it references a company called Kodak. All of you remember Kodak. Certainly those of you above 30 remember Kodak. And remember that Kodak was the industry leader, bar none, in the photography world. If you wanted to take a picture, you typically had to use Kodak film. You had to take it to get developed. You had to use a single lens reflex camera. And that's how we made pictures. And Kodak actually in the 70s developed digital photography, but the folks at the management of Kodak said, well, we don't want that new technology. The public, the consumer, is never going to use digital photography because our product is so much better. And Kodak didn't react. It dragged its feet, in fact, and didn't enter the digital market. So we all know that Kodak is virtually gone now. None of us uses Kodak, or very few of us use Kodak, and certainly not to the degree that we used it before. So looking up on the screen here, you see 4 companies, and the question I ask is, where are they now? Where's Blockbuster? Where's Specs? Where is Borders and where is Kodak? And the issue is not what they did, it's what they didn't do. They didn't adapt to the marketplace. They didn't recognize the power of the public. They didn't recognize the choices made to the consumer that provided alternatives to their product. So here's the new marketplace. The incumbents have been overtaken by internet-based tech platforms. Borders was a bookstore. Amazon started as a bookstore. It's now an over $90 billion provider of goods, one of the largest companies in the world. It has no bricks. It has no storefront. In fact, it has a store in Seattle, I believe. But other than that, Amazon is a 24/7, affordable, convenient, accessible platform for the public, for consumers to buy goods. We take pictures on the iPhone now. We send texts, we Instagram, we Snapchat. We use tech platforms, the phone, to replace virtually Kodak. Netflix gives you the opportunity to watch a movie or watch a series when you want, how you want, and on your terms. Spotify provides virtually unlimited access to music from your iPhone. These companies that didn't react have been replaced by companies that saw the power of technology, that leveraged the power of technology to provide consumers with access to their goods and services. This is a diagram of the internet and the increase in internet usage. The internet was born effectively in 1991. In the first 10 years of its existence, give or take, 1 billion people got onto the internet. In the second 10 years of life of the internet, it doubled to 2 billion people. So there are 3 billion people now with access to the internet, and the information we have tells us that by 2020, which is just 4 years from now, 66% of the world's population will be on the internet, and the new thinking is about 90% of the world's population in 4 years will have access to the internet in one form or another. So we have a new marketplace that we're dealing with. Things that can be commoditized, information, will be. Things that can be packaged, forms, will be. Things that can be standardized, processes that can be standardized. The process of doing things that we do. So information, forms, process are things we deal with as lawyers. And if they can be commoditized, packaged, or standardized, they will be. Non-lawyers are clearly into the marketplace, and free is a driver. Free is a driver because we all like things that are free. We don't go to the store and ask to pay for something if it's given to us free. If Publix or Amazon offered you a product for free, we would take it because we like free. The founder of Expedia.com has said, if it can be free, it should be free, and it will be free. Ravel Law has just bought the entire Harvard Law Library and is digitizing the library and making it free to the consumers, to the public, to the we the people of the Constitution. They call that the Free Law Initiative. Platforms like LegalZoom and Avo and Rocket Lawyer provide free legal advice. They provide free access to legal questions and answers. So the consumers are going to those platforms driven by free. We, as lawyers, have to consider how we're going to work in that new environment. This is an example of a will I picked up on the internet, and they advertise cheap, quick, and easy because that's what the consumer wants. And clearly, a consumer doesn't want to wait to talk to a lawyer today, tomorrow, next week, when it's convenient for the lawyer. If the consumer at any particular time decides he or she wants to do a will, they're going to go on the internet. Consumers are going to go on the internet. Consumers are going on the internet. The public is on the internet. The internet is everywhere. And folks on the internet, companies on the internet, are providing things to the consumers, just like us, that are cheap, quick, and easy. LegalZoom has been battling the unauthorized practice of law issue. This is a sampling of the news articles from LegalZoom in North Carolina. LegalZoom actually sued the state of North Carolina and ended up with a consent judgment in the state that allows LegalZoom forms to be used in one form or another in the state of North Carolina. And the issue there is access. These platforms provide affordable, convenient, accessible access to the public to things that we lawyers have typically done. Avo's just rolled out a fixed fee legal services. You can go on the Avo platform, and in addition to getting answers to common legal questions for free, in addition to being able to access a lawyer for $49.95, now if you have a legal problem, Avo has used its business acumen and the power of its computer processing to provide fixed fee to consumers. Avo, LegalZoom also brand. We as lawyers don't advertise. We don't have the budgets to advertise for many reasons, but here are some commercials that Avo and LegalZoom use to brand their product, to drive consumers onto their websites. None of this is done by the Florida Bar or any other bar in the state, and certainly the only lawyers that advertise in Florida, for example, don't have the money or the prowess or the branding expertise that these companies do. Rocket Lawyer is another internet-based tech platform that provides a different access point. You'll see here Rocket Lawyer's business model. 30-minute free consultation. There's that word free again. 40% discount on published fees. Rocket Lawyer provides access to the consumer and support to the lawyer on the back end so that the lawyer can actually reduce its fees and, according to Rocket Lawyer, make more money. What you'll see next is a clip for a company called ModeRIA. ModeRIA is an online dispute resolution company. It comes out of the eBay ecosystem. If you think about eBay, it is a worldwide platform. People from China can interact with people from Europe or South Africa or the United States or South America. Where there's people, there's eBay engaged in e-commerce. So the question I have for you to think about, take a second. What is the law that applies to an eBay transaction? What is the law? Not the jurisdiction, because that's the law. Where do you go if you have an eBay transaction to resolve the natural disputes that occur when human beings interact in commerce? And so that was the problem that was addressed by the eBay folks, and they went to a guy named Colin Rule, who created an online algorithm for eBay. And what it does is it allows two consumers involved in e-commerce to go to an online portal, answer a series of questions, and resolve their legal disputes in a predictable, fair manner. And there is the law of the internet. The law of the internet is the law of eBay. The law of the internet is the law of commerce, not driven by jurisdictional issues, not driven by venue, not driven by countries, not driven by borders, driven by the practical reality of a borderless e-commerce platform. So Mr. Rule created a company called ModeRIA, and I'll show you what ModeRIA does now.
In the old days, all disputes happened face-to-face. Today, we spend 35 million hours online every month, and over 400 million consumer and business disputes are created every year. How can we resolve this many disputes fairly and efficiently? Introducing ModeRIA, the Internet's justice system. We built and scaled the resolution systems at eBay and PayPal that solve over 60 million cases every year. After handling 400 million cases, we learned a thing or two. ModeRIA combines the power of automation with the wisdom of decades of dispute resolution experience. We keep the process human. Everyone can fully participate and be heard, ensuring a fair hearing and better overall experience for all parties. We handle every kind of dispute, including customer problems, complicated and sensitive business-to-business issues, legal disputes, government complaints such as property assessment appeals, and many more. All inside the most secure online dispute resolution platform ever built. ModeRIA puts you in control with powerful, intuitive tools, state-of-the-art security, and the ability to manage cases from anywhere in the world on any device. ModeRIA's more efficient dispute resolution system will help you get your life back by managing your case backlog, reducing legal risk, cutting overhead costs, increasing revenue, and most importantly, freeing you up to spend your valuable time on growing your business. Perhaps even taking that much-deserved vacation. Are you ready to take control and turn your disputes into solutions? Get your hassle-free ModeRIA demo today.
So what you've seen now is ModeRIA self-proclaimed as the justice system of the internet. What impact does e-commerce, what impact do borderless transactions have on our justice system, our judicial branch? How are online disputes going to be resolved? And how are other disputes going to leverage the technology available today from companies like ModeRIA to resolve a myriad of other disputes? ModeRIA is here and growing. In England, if you have a dispute below £25,000, which is about the equivalent of $50,000 in the United States, you have an option to go to a ModeRIA platform, the two people in the dispute, and have ModeRIA use its technology and its algorithms to resolve the dispute. Again, predictable, affordable, convenient, cheap, quick, and easy. So how do lawyers fit into this? Because we're not cheap, quick, or easy. What we do, the value we bring, our professional identity is really now been called into question because of the fact that we have competition and the type of competition we have and the market pressures that are being put on us as lawyers. So that brings us to the bedrock of our profession, ethics and professionalism. What we do and how we do it. Ethics, how we must behave. Professionalism, how we should behave. We've never really identified our professional identity. These are some things that we've come up with about what we do as lawyers. We understand the rule of law. We understand the justice system. Many of us work in the justice system. Certainly we understand individual rights, civil rights, LGBT rights, women's rights. All of those rights are in the Constitution and have been created through the efforts of not only the founding fathers, but lawyers and judges interpreting the Constitution to have those rights. The common good, loyalty to clients, confidentiality, things we have as part of our professional identity that we provide to consumers. Independent judgment. Judgment is not cheap, quick, or easy. We keep professional distance. We have principles of integrity, honesty, and service that we provide to our consumers that distinguish us from non-lawyer, internet-based, or non-lawyer service providers that we are now clearly competing with. Brings us to a value proposition. I have never been asked, and the lawyers I've talked to in those 252 meetings, we've never been asked, what do you do as a lawyer? What is it that you bring? What is the value that you bring? Why could I buy your product or your service versus buying it from now over 1,000 options on the internet? So we have to talk about our value. Professionalism and ethics we've covered. We do analysis, judgment, strategic thinking, counseling, and service. And certainly none of those are cheap, quick, and easy. We have to evolve from the role of attorney or litigant or combatant and create an atmosphere of trust with our clients. We have to go back to being counselors. When I first started practicing law, my card said attorney and counselor at law. Before I started 30 years ago, it used to just say counselor at law. And then we turned ourselves into attorneys, and then we became business folks. And now we're competing on a business platform, and we have to address our identity and our value to the consumer. And our genuine, most authentic value is trust and counseling with the consumer. So that leaves us with the Supreme Court. And you'll see at the beginning we started separating, now we go back. We have to engage in a dialogue with the Supreme Court. We have to make sure that we are providing information both to the bar examiners and to the Supreme Court, and ask the Supreme Court to help us navigate this road into the future, to help us adapt to the marketplace, to rethink our rules that were created at a different time. Before, internet-based technology platforms created an opportunity for consumers to go elsewhere. We need to work with, partner with these platforms or create our own so that we can provide the services that the Supreme Court asked us to the public, so we can restore the public's confidence in the bar and in our profession, and so we can adapt and thrive in the new marketplace. Thank you.